let's talk about AB5. Now, depending on what you've heard of AB5, it's either the end of our country or the end of the world. I have a little bit of a different opinion, and we'll get to that in a little bit. But today, I want to break down AB5. I want to talk about some specific legal terms that are helpful for understanding what AB5 is all about. Judicial precedent around common law, statutory law, codification of laws, and a designation between employee versus independent contractor. As always, nothing I say here is intended to be legal advice. I'm not trying to establish an attorney-client relationship. I am just trying to explain something that a lot of us in the supply chain have been scratching our heads over. Now, before we get to AB5 and the ABC test, let's talk about something a little bit different. Let's talk about space. What is a planet? What is a dwarf planet? Well, there's a three-part test for that. And what is that three-part test? Number one, the object must orbit a star. Number two, the object must achieve hydrostatic equilibrium. That means that the object is so massive that it becomes a sphere, a ball. And finally, the object must clear its orbital path. So let's take some examples and see if it passes the test. Jupiter. Does Jupiter orbit a star? Sure it does. Does it achieve hydrostatic equilibrium? Is it a sphere? Sure it is. Does it clear its orbital path? Absolutely. How about Ceres, the object in the asteroid belt? Ceres accounts for about 25% of all the mass in the asteroid belt, and it has a few things. It orbits the sun. Number one, check. Does it have hydrostatic equilibrium? Of course it does. It's a sphere. It's a ball. Check. Does it clear its orbital path? It does not. And as a result, all that debris, it is a dwarf planet, a scientific designation. This is the same challenge that Pluto ran into. Pluto, again, orbits the sun. It is a circle, it is a sphere, and unfortunately, it doesn't clear its orbital path. Now, we won't talk about the barycenter, which is the object that when two things are orbiting each other, it's where the center of mass is. But for Pluto's moon, Charon, their barycenter is actually outside of Pluto. Suffice it to say, Pluto doesn't pass the test, and therefore is not a planet. This is our segue into talking about the designation between an employee and an independent contractor, and what we know of as the ABC test. Now, the ABC test in AB5 goes a little bit something like this. A. The worker is free from control and direction in the performance of services. B. The worker is performing work outside the usual course of business of the hiring company. And C. The worker is customarily engaged in an independently established trade, occupation, or business. What this shows is that it's a three-part test. Fail any one of these points, and you are, in fact, an employee. If you pass all of them, you are an independent contractor. Now, a lot of people think that AB5 came out of nowhere. That could not be further from the truth. AB5 is actually a result of taking a legal case called Dynamax from 2018, which was considered common law, which essentially common law is judicial precedents. The judges that interpret the different rules and regulations create a series of opinions that shape what the law is. If you don't like the common law, which is what this was, you seek to codify it. Codification is taking common law and putting it into statutory law, which is essentially legislature passes a bill, it goes to the executive, in this case the governor, and they sign it. That is the process of codification. So Dynamax was a case in 2018. Let's look at the facts of Dynamax. For my supply chain folks, you're probably going to find this case pretty interesting. I'm going to read the facts and then we'll apply the test. So, number one, Dynamax was a corporation that offered same-day courier and delivery services nationwide, including California. Dynamax enlisted drivers to complete the pickups and deliveries at the core of its business. Before 2004, Dynamax classified all of its California drivers as employees and compensated them in accordance with California's wage and hour laws. But starting in 2004, the company chose to classify all of its drivers as independent contractors in order to achieve cost savings associated with avoiding the obligations that those laws impose. Under this policy, Dynamax hired drivers to provide delivery services for an indefinite period of time, but could terminate this arrangement at any point as long as Dynamax provided 3 days' notice. Drivers could set their own schedule, but had to notify Dynamax in advance of the days they wished to work. On these days, a Dynamex dispatcher would assign available deliveries to drivers, although Dynamex did not guarantee drivers the number or type of deliveries in advance. Drivers could reject delivery requests, but were required to communicate quickly with the dispatcher if they wished to do so. Compensation depended on the type of delivery, but drivers were either paid a flat fee per delivery or a percentage of the delivery fee paid by the customer. Not including drivers in compensation were various tools of the trade, which drivers used to complete their deliveries and were required to purchase themselves. Drivers were required to purchase delivery vehicles, as well as any related transportation expenses such as gas, maintenance, or insurance on their vehicles. Drivers were also required to purchase a Nextel cell phone to communicate with dispatchers. In addition, they were required to purchase Dynamex shirts and badges and wear them while completing deliveries. That was the facts of Dynamax. Now, before Dynamax, before the test that we know now as the ABC test, there was another test. Back in 1989 in California, there was another test understood as the Borello test. I won't get into the Borello test, but I'll put some of the things about Borello in the show notes. Suffice it to say, it had the first part of the ABC test, the control aspect, but there were 8 other factors. Very complicated and hard to put in place, so the ABC test was taken. So looking at the facts of Dynamax as it relates to the ABC test, what did the court do? Well, first they said, we're gonna say that's fine. They have control. The people can make their own schedules. They don't have to do it what Dynamax tells them to do. But they said in part B of the test, the delivery of these things was the core business of Dynamax. So the worker is performing work outside the usual course and business of the hiring company? No, the court says. That is the core business of the company. Not the idea that these are independent contractors. The core business is these drivers. And Part C, they also would fail, and that was that this was not independently established trade, occupation, or business, customarily in the business. Why? Well, Dynamax had them as employees for the entire time up until 2004. That is what established the ABC test, and in this case, Dynamax failed. So what happens next? Well, AB5 begins to promulgate within the legislative world, and the codification takes place. It becomes law, not just on the common law, but statutory law. Again, not a big difference than what it was before, but now it's out there in front of everybody. During this time, Proposition 22 shows up, which is the gig company spending $200 million to have themselves exempted. This then goes to is still in litigation right now, so we'll see what happens with Prop 22 down the road. But AB5 remains the law of the land. Many companies fought AB5 in court, and eventually a writ of certiorari was put together. They tried to petition for certiorari. Please, Supreme Court of the United States, rule on this case. Give us a stay from AB5's draconian measures of making everybody employees. Well, the Supreme Court said no. This is just a question of distinction, a legal distinction based on what the state wants to do as to what is an employee and what is an independent contractor. Here's the deal. AB5 codified the existing common law of the state of California. These cases around classification aren't about me wanting to have my own independent company. Generally speaking, it is a way to avoid wage and hour, worker compensation, and unemployment insurance, which is what drives the cost up for so many trucking companies. And these changes, although interesting, are not new. California's had these laws in some iteration since '89, for decades. So as you read these things and you read about the protests, which I believe now are all done, understand that AB5 is something that is a codification of existing common law. It is not necessarily a new thing. It is a test, a 3-part test, which establishes a presumption that somebody is, in fact, an employee. You can disprove it by rebutting that presumption. As always, thank you for tuning in. I hope this video was helpful, and have a great day.